Hello everyone, my name is Alexia Klingen. I'm honored to contribute to this volume of the Elpis v. Law Review and would like to thank Professor Vasco Pereira da Silva and Dr. Dimitrios Parashu for this opportunity. Today I'll be talking about the challenges and the basis for the extraterritorial application of the General Data Protection Regulation, the GDPR, which is a response to the need to go beyond the traditional application of the law, as the Internet and the relations that derive from it are not constrained by territorial borders or jurisdictions. The Internet has become an integral part of the functioning of civilization, so the notion that it should not be regulated has been largely overcome. Instead, a new issue has emerged, namely, who should regulate online activities? The reason why this question is so difficult to answer is the way the Internet is structured. It is an amalgamation of countless individual networks that communicate with each other electronically, and its global nature makes it difficult for centralized management or control to exist. Additionally, as mentioned before, the extraterritorial nature of the Internet is practically incompatible with the usual scope of law, which is traditionally correlated with the territory of the legislator for reasons of sovereignty and effectiveness. However, since there is no global authority to regulate the cyberspace, states are led to unilaterally regulate cross-border activities. The GDPR follows this new trend by introducing the marketplace principle and extending its application beyond the EU territory. Understanding the extraterritorial effect of the GDPR is important not only because it is a prime example of a modern data protection regulation, but also because it can set global standards. The revised version of Convention 108 ensures that the principles and rules laid down in the GDPR have an impact far beyond its territorial scope by acting as an exporter of the European data protection law to the member states of the Convention outside of the EU. The marketplace principle is established in Article 3, Paragraph 2 of the GDPR, and should provide protection for individuals inside the EU against data processing from outside it. Accordingly, the regulation applies to the processing of personal data of individuals located in the EU when the data processing is carried out by a controller or processor not established in the EU for the purpose of offering goods or services or monitoring the behavior of a data subject. In order to ensure that there is a substantial link to the EU, Recital 23 of the GDPR has established contexts that demonstrate the apparent intent to offer goods or services to individuals in the EU by non-EU businesses. Examples are the use of a language or a currency from one or more member states, as well as whether the company has a website with a country-specific address or a payment or shipping option specifically for EU member states. In addition, Recital 24 sets out criteria for determining if a conduct can be considered as monitoring of behavior of data subjects, and thus triggering the application of this regulation. For this to happen, it should be determined whether natural persons are tracked on the Internet, including the possible subsequent use of personal data processing techniques consisting in profiling a natural person, in particular to make decisions regarding that person or to analyze or predict their personal preferences, behavior, and attitudes. Nevertheless, the clarity and practicability of this article is controversial. Some defend that there is no ambiguity of the extraterritorial provisions of the GDPR, as its application depends on the rules that are clearly set out in the regulation and its recitals 23 and 24. Others, however, claim that although this article seems to offer certainty, predictability, and simplicity in theory, it is unthinkably difficult to apply in practice. Ultimately, the precise application of Article 3, Paragraph 2 can only be further developed through its practical application and the establishment of guidelines by the European Court of Justice. As for the challenges of the extraterritorial effect of the GDPR, the three main ones are the effectiveness of its enforcement, the conflict with other data protection regulations, and the fragmentation of the Internet. Some companies from countries outside of the EU will voluntarily comply with the GDPR in order to develop a good business image as well as data protection practices. Others will follow directions from EU data protection authorities and comply with orders or rulings from EU courts to avoid reputational damage. However, in the remaining cases, enforcement might be necessary, and this is where the problem lies. Although data protection authorities can initiate court proceedings to enforce the provisions of the GDPR, such recourse to courts against non-EU organizations is practically ineffective. Essentially, recourse to an EU court is of little use unless the organization is based in the EU. For example, if there are no assets located in the EU, the seizure of assets cannot be done by the European Court without cooperation from the authorities of the country where the organization is based. Additionally, if the requirement of Article 27 of the GDPR is not met, namely the appointment of an EU representative, enforcement against them is impossible. Even the service of a penalty notice can easily fail on a global level. The second challenge arises when different regional laws impose far-reaching obligations that clash with each other, raising the question of which law actually prevails. India's Personal Data Protection Bill, the PDP, and the US Clarifying Lawful Overseas Use of Data Act, the so-called Cloud Act, can be cited as examples. In practice, this brings two data protection laws into conflict with each other, which could lead to legal difficulties for companies that need to understand their obligations under each regulation and act accordingly to avoid heavy fines. The third challenge posed by the marketplace principle is the fragmentation of the Internet. This would occur through the introduction of stricter legality requirements for the processing of personal data and the strengthening of information rights in countries that previously either had no or only weak data protection laws, creating sub-networks whose services are only accessible to those residing in a particular jurisdiction or whose access is denied to users from certain territories. The strongest basis for the extraterritorial application of the GDPR is perhaps the fact that the exercise of extraterritorial regulatory sovereignty has now become indispensable due to the advancing interconnectedness of the information society. Furthermore, its alternatives, such as the restriction of cross-border data traffic, the self-regulation of the market, or the global harmonization of data protection law, are either not equally suitable for ensuring functioning of data protection or cannot be implemented in the foreseeable future. Therefore, despite the obstacles mentioned above, the extraterritorial application of the GDPR is the best option to ensure sufficient protection of data subjects in the EU. The extraterritorial application of the GDPR can also be justified by its leveling the playfield aspect, the aim of which is to create an equal set of rules for all actors in the European internal market. Without the enforcement of the marketplace principle, the EU would have to endure that compliance with the GDPR would leave European companies at a competitive disadvantage in the European market. Moreover, since the extension of the scope of the GDPR outside the Union is limited to cases that are directly related to EU territory, the extraterritorial application of EU data protection law has identifiable jurisdictional basis under public international law. First, it can be said that its extraterritorial effect is actually based on territoriality, as it is triggered by a territorial connection of an activity or a person with the EU. This is the case with the triggering of the application of the regulation regarding companies not established in the Union through their targeting or monitoring individuals in the EU. Second, this application is related to individual rights based on a person's affiliation with the EU. As a result, the EU's claims may be justified under the passive personality principle, which allows the EU to protect its citizens, residents, and anyone in its territory. Finally, advocating against extraterritorial application to solve the problem of overlapping jurisdictions of data protection laws would only lead to further infringement of the informational privacy of data subjects by foreign companies, as one could argue that the real conflicts do not lie in the legislation itself, but rather in the divergent legal environments and privacy cultures. To conclude, given the new international context created by the increasing development of technology, the proliferation of the internet and globalization, it is clear that the GDPR follows the global trend of expanding the scope of data protection laws. Therefore, this extraterritorial application of European law to non-EU organizations is justified by the borderless scope of the Internet, which in return also requires a borderless application of the law. A domestic scope of application is not sufficient for effective data protection on the Internet, as the offers of products and services and the monitoring of individuals are not limited to the territory of one country, but can come from anywhere in the world. In this sense, it can be confirmed that despite the uncertainty of the application of Article 3, Paragraph 2, as well as its aforementioned challenges, the extraterritorial effect of the GDPR is currently the best option to protect privacy and personal data. Ideally, there would be an international data protection law that would not only solve the obstacles of enforcement and conflict between jurisdictions, but could also be a step towards solving the jurisdictional problem of regulating the Internet. But while this is not the case, the GDPR can be used as an international model.